So, why is it so important, so critical to register your US copyrights in your creative works in the United States? Hello and welcome. This is US copyright attorney Eric Kelly. In this video, you should learn why it's so important, why it's so critical to register your US copyrights in your creative works in the United States. And you'll learn why it's important to pursue your US copyright registration as soon as possible rather than waiting on to seek US copyright registration. Okay, let's get into this. In my mind, there are at least three main reasons why it's important to seek US copyright registration of your creative works. So number one, I would say, pertains to how the US enforces copyrights. So the first reason is about enforcement of the copyright as being the primary driver as to why you want to seek US copyright registration in your creative works. Number two pertains to the marketability of your creative works. So having a US registered copyright in your creative works can help with the marketability of your given creative works because it establishes a presumption of who actually owns that creative work and that it's protected. And lastly, the third point here as to why it's important to seek US copyright registration is that US copyright registration, out of all the different types of intellectual properties as compared to like US patents or US federally registered trademarks, US copyright registration is the cheapest of those three. So seeking US copyright registration is often a relatively affordable process. It's not too expensive, at least compared to seeking a US patent or compared to seeking a US federally registered trademark. So US copyrights are how creative works are protected, which then kind of raises the question, so what are creative works? What am I even talking about when I say creative works, which are the things that can be protected by US copyrights? So I'll give you a bunch of examples of different types of creative works, of things that can be protected by US copyright. And this is not an exhaustive or complete list. These are just some examples. So one type of creative work that can be protected by US copyrights are videos. Pretty much any type of video. It could be like an advertising commercial, it could be a YouTube video, or any other video that you might see somewhere, or a video you shoot yourself, whatever. Videos in general can be protected by US copyright. Videos generally are some form or some type of creative work. Motion pictures are another example of a creative work that can be protected by US copyright. Photographs, another example of a creative work that are often protected by US copyright. Another example would be music. And music is somewhat similar to motion pictures in that there can be a number of different copyrights actually embodied into that. For example, with music, you can have like the written music, the sheet music, the musical composition, the lyrics, the arrangement, the composition. You can also have the performed music, which is often done as what we'd call a sound recording. So anyway, music is a type of creative work that can be protected by US copyright, and music can have various different types of various different types of copyrights in it depending upon what aspect of the music you're talking about, such as whether we're talking about the musical composition and or we're talking about the sound recording. Another example of creative works are literary works, so things like novels and books and poems. They can be works of fiction, can be works of nonfiction, although copyright does not protect data or facts or information. So generally, the copyright that exists in a work of fiction is going to be stronger than the copyright that exists in a work of nonfiction. But there still can be a copyright in nonfiction. So other examples of creative works that can be protected by US copyrights are things like scripts, screenplays. You can have art in whether you're thinking like graphic art or musical art or whatever. Art in general can be protected by US copyright because art is a creative work. So artwork, graphic arts, visual arts, 2D art, drawings, paintings, 3D art, sculptures, all of those in general are creative works that may be protected by US copyright. Another example would be jewelry, and jewelry is often basically a form of sculpture. And when we're talking about copyright protection for jewelry, we're talking about the non-functional jewelry, so things like necklaces and bracelets and earrings and rings and things of that nature. Whereas we're not talking about functional jewelry as in like a wristwatch or a stopwatch or a pocket watch, because copyright in general does not extend to functional items. Other types of creative works that can be protected by US copyright can include like animations. Some aspects of software can also be protected by US copyright. Sometimes a logo can be protected by US copyright because a logo is essentially just artwork. But again, the logo generally has to have a certain level of creativity to it. It can't just generally be some letters or numbers. It generally needs some kind of graphic elements to it to at least have enough there for it to be protected by US copyright. Other examples could be like a website or a web page layout. Those are other examples of creative works that could be protected by US copyright. So anyway, again, this isn't a complete list. These are just some examples of different types of creative works that can be protected by US copyright. So if you're generating any of these types of creative works or other types of creative works, you really want to be thinking about, am I protecting my creative works by registering my copyrights in these creative works? You want to be able to protect your creative works. Also note with respect to creative works, it does not matter at all whether or not the given creative work is something that exists in the physical world, something that's tangible, or something that is purely, digital or electronic. Either one or both are types of creative works or can be types of creative works that can be protected by US copyright. So, digital creative works as well as, physical tangible creative works, either one or both can be protected by US copyright. So now that we have an idea of things that can be protected by US copyright, such as creative works of all different types, what exactly is a copyright? So what do we mean when we say copyright? So there's one good way of looking at this, and this isn't the only way to look at this, is that if you look at a particular law that's found at Title 17 of the United States Code, Section 106, this defines or sets forth 6 different rights that come with having a US copyright. So let's go through some of this. So if you own a US copyright, okay, basically subject to some exceptions, the owner of the copyright has the exclusive right to do and to authorize any of the following. Number 1, to reproduce or copy the copyrighted work in copies or phonorecords. So that's kind of the first right you have. It's basically the right to reproduce or copy. Additionally, you have number 2, you have the right to prepare what are known as derivative works based on the original copyrighted work. A derivative work is just something that would be based upon the original work, okay? So you also have that right that comes with your copyright. Number 3, you have the right to distribute copies or phonorecords of the copyrighted work to the public by sale or transfer of ownership or by rental, lease, or lending. So basically that's your distribution right. You have the right to distribute copies of your given creative work. Number 4, and this is a performance right. In the case of literary, musical, dramatic, and choreographic works, pantomimes, and motion pictures, and other audiovisual works, you have the right to perform the copyrighted work publicly, okay? Number 5, this is your display right. In the case of literary, musical, dramatic, and choreographic works, pantomimes, and pictorial, graphic, or sculptural works, including the individual images of a motion picture or other audiovisual work, you have the right to display the copyrighted work publicly. And then the last right here is another type of performance right. Number 6, in the case of sound recordings, you have the right to perform the copyrighted work publicly by means of a digital audio transmission, okay? So if you're the owner of a copyright, you have this bundle of 6 different rights that you can do that are attached to your copyright in whatever the given creative work might be. So someone cannot use your creative work or a portion of your creative work in any of these 6 ways unless they have your permission. That's what the copyright right gives you, okay? If someone does use your copyrighted work or a portion of your copyrighted work in any of these 6 ways without your permission, then that may be copyright infringement, US copyright infringement. However, when we first started this particular list of 6 different rights that come with the copyright, I basically started that out by saying subject to some exceptions. So there are some exceptions in the statutory law for US copyright that where these 6 rights may not exist or may not apply. These exceptions, these statutory exceptions in the law are set forth at Title 17 of the United States Code, sections 107 to 122. And section 107 in particular, that's the U.S. copyright fair use statute, which is an affirmative defense. And U.S. copyright fair use is incredibly widely misunderstood and misused. U.S. copyright fair use is beyond the scope of this particular video, where we're kind of just focusing on why registration of your copyrights is important to do. So to recap, if someone uses your copyrighted work or a portion of your copyrighted work in any of these 6 ways without your permission, then that could be infringing your copyright. And you can have a right to go after that person for the harm they've caused you by infringing your copyright. Also note when I say that this can apply to not just your entire creative work, but it can apply to, the copyright can apply to if someone just uses a portion of your copyrighted work. That has some nuance there. If someone just uses the bare minimum, just a tiny bit of your copyrighted work, that might not rise to the level of copyright infringement. Unless they're using, the bare minimum that they're using happens to be a really important part, such as like the hook in a song, then that still might rise to the level of copyright infringement. So there can be some nuance to this. Recall when we first started here, I mentioned that there's at least 3 main reasons why it's important to seek U.S. copyright registration in your creative works. With the first reason pertaining to it's important for your ability to enforce your U.S. copyright in your creative works. And number 2 was with respect to having a U.S. copyright registration can improve your marketability for that creative work because it sets forth who the owner is and it gives you those rights that we just saw with the copyright, those 6 different rights. And 3 pertain to the fact that generally speaking, seeking U.S. copyright registration is relatively affordable. So let's talk more specifically about the enforcement process of a U.S. copyright. If someone uses your copyrighted work or a portion of your copyrighted work without your permission in one or more of those 6 different ways, such as copying, without your permission or distributing, for example, such unauthorized use may be U.S. copyright infringement. So how do you then enforce your copyright against the infringer? I generally look at enforcing an infringed U.S. copyright at 3 different levels of escalation. And generally, as you escalate up those different levels, the cost generally increases as well. So beginning with the lowest level of escalation and the lowest level of cost, I will typically start this enforcement process, what's typically called a DMCA takedown notice. And the DMCA takedown notice generally gets submitted or directed to the third-party online platform where the infringement is occurring. So generally what that means is that some other person or business or whatever has infringed your copyright on some platform, some online platform like YouTube or TikTok or Amazon or whatever, but that platform itself is not necessarily the direct infringer. That's just where the infringement is occurring. It's somebody else has submitted or uploaded something to the platform and they're the infringer. So to provide immunity to the platform itself, we have this DMCA takedown notice process. So you submit your DMCA takedown notice to the platform itself, and then the platform will remove the offending content. However, the platform will then also notify the alleged infringer about the takedown, and this is where one of the problems can arise with this particular process. The alleged infringer can file a counter notice. And if they file a counter notice, then the offending content goes back up. And so then the DMCA takedown notice process doesn't really work. Now, if the infringer doesn't post that counter notice, then this DMCA takedown notice process can be very effective and very cheap, very affordable. Another issue that can arise under this particular situation with these third-party platforms where the infringement may be occurring is that only U.S. companies have to follow this law. It's a U.S. law. So generally, if the third-party online platform is not a U.S.-based company, they don't have to follow this process. Now, some foreign third-party online platforms will still follow this process because they do have a lot of customers or people that use their service from the United States, but just know that could be a potential issue here. So the 2 weaknesses with the DMCA takedown notice process are one, that the direct infringer might file a counter notice, and or 2, that the third-party online platform might not be one that follows U.S. law. So in any event, if a DMCA takedown notice cannot work or doesn't work, then the next level of escalation, generally, at least for me, often is what I would call an attorney drafted, so a lawyer drafted cease and desist letter. And it could be an email, or a letter that you mail out, but it gets directed to the actual direct infringer, which explains what kind of infringement's going on and why it needs to stop. So those are the first 2 levels of this enforcement process. Number 1 being the DMCA takedown notice, and number 2 being an attorney drafted cease and desist letter, what's often called a C&D letter. So if options 1 and 2 were tried and they don't work, then the third level of escalation here, and the most expensive, is preparing, filing, and serving a U.S. copyright infringement lawsuit against the defendant. So given these three different levels of how we enforce the U.S. copyright when there's an infringement issue going on, so how does this relate to why it's important to have a registration in the copyright? So first of all, with respect to number 1 and number 2 here, the DMCA takedown notice and the cease and desist letter, technically you do not have to have a U.S. copyright registration to do a DMCA takedown notice or to have an attorney drafted cease and desist letter. However, generally speaking, the DMCA takedown notice and or the attorney drafted cease and desist letter will be in a stronger position legally if the U.S. copyright had been registered. You'll be in a stronger position to make those claims against the infringer. But for number 3, preparing, filing, and serving the U.S. copyright infringement, there's a flat out just prerequisite that the registration must be done before you can file the lawsuit. So that's a primary reason why you need to get your copyrights registered, so you actually have the ability to sue someone for copyright infringement. Under this particular law, Title 17 of the United States Code, Section 411 sets forth that it's a prerequisite that the copyright registration must be registered. You must have a U.S. copyright registration before you can file and maintain your U.S. federal copyright infringement lawsuit. So that's a real important reason why you want to have or seek your U.S. copyright registration in your creative works. Now, additionally speaking, with respect to the U.S. copyright infringement lawsuit, if you did your registration in a timely manner, according to another law, which is Title 17, United States Code, Section 412, if you've done your registration before infringement or within 3 months of a first publication of the given copyrighted work, then you're able to get what's called statutory damages, and you might also be able to recover your attorney fees in the lawsuit. So those are both really important. Statutory damages are covered under this particular law, Title 17 of the United States Code, Section 504, and statutory damages are essentially like a fine imposed by the law. So if you're suing someone for U.S. copyright infringement and you did your registration, your copyright registration before the infringement, or at least within that safe harbor provision rule within 3 months of the first publication, you're eligible to get statutory damages, which again is just like a fine. So essentially you, the plaintiff, basically gets paid from the defendant, the infringer, whatever the fine may be. And that's beneficial to you, the plaintiff, to the owner and the copyright. In contrast, if you had done your registration after the infringement occurred and not within that safe harbor provision, then you're not allowed to get statutory damages. Instead, what you're limited to get are what are called actual damages. And the problem with actual damages in a U.S. copyright infringement lawsuit is, number 1, actual damages can be difficult to prove. And number 2, the actual damages can a lot of the time be really small. So it may not make the U.S. copyright infringement lawsuit worth your while. Whereas if you can get the statutory damages, that may be significant and you don't have to prove them. So that's why statutory damages are often more beneficial than going after actual damages. But you can only get statutory damages if you registered your copyrights before the infringement occurred or within 3 months of the first publication of your creative work. Now, additionally, if you did your copyright registration and the timing of your copyright registration was good, you might also be able to recover your attorney fees, which can also be very significant. And so that's a big deal. Now, the attorney's fees is set forth at Title 17, United States Code, Section 505. Okay, so let's look at 3 different scenarios here. Scenario A is that you registered your U.S. copyright before the infringement occurred. And under that situation, you may be able to get the statutory damages in the lawsuit, and you may be able to get your attorney fees covered. So that's great, and that's a primary reason why you want to get your U.S. copyright registration done before there's any infringement. Okay. Scenario B, or you register after the infringement begins, but you do your registration within 3 months of your first publication. So again, according to that safe harbor provision of Title 17 of the United States Code, Section 412, under that scenario, you still could be entitled to go after or get statutory damages and have your attorney fees covered. Again, so that's a good situation. But in general, the preference is to have that copyright registration done as soon as possible so that it's done before there's any infringement. Then you don't have to worry about whether you fall within that safe harbor provision of that 3 months, within that 3 months of first publication rule. Now, additionally, how U.S. copyright law defines publication is not necessarily, or it's definitely not the same as like your general everyday English way of publication is used. So if you look at Title 17 of the United States Code, Section 101, that's where a lot of the terms in U.S. copyright law are defined, and publication is one of those terms that does get defined under Section 101 of Title 17 of the U.S. Code. So you can check that out if you want to see how U.S. copyright law actually defines publication. Again, so then going back to, we talked about scenario A, scenario B. So the third and final scenario would be scenario C, which is you did your U.S. copyright registration after the infringement began, and you don't get the benefit of that safe harbor provision. So under that situation, basically you're not going to be able to get statutory damages, and you're not going to be able to get your attorney's fees covered, and you can only recover your actual damages. For most types of copyright infringement, that's going to not be a very desirable situation. So this kind of all boils down to, or comes back to, A, you really want to get your copyright registration done for your creative works, and B, you want to get it done as soon as possible so you can receive those benefits, the full benefits under the law, which is things like going after statutory damages and having your attorney fees possibly be recoverable. Okay, so what you're seeing here is the United States Copyright Office's website, their homepage, at least as of March 2023. So you can see that's the copyright.gov is their basic website address, and this is where you would go to register the copyrights in your creative works. So you'd go under, for example, registration. You click on their portal, and you click this login link, and you have to have an account with them, but that's pretty simple. Anyway, but I mentioned there are 3 reasons why you want to pursue U.S. copyright registration is that it's a relatively affordable process. So let's look at the Copyright Registration Office's governmental filing fees. So I've entered fees into the search window just to pull up their fees quickly. So we'll look at their registration fees. So if you're doing, you can see right here, for a single author, same claim, it means the author and the owner are the same person, one work, not a work for hire. The lowest filing fee is $45 as of March 2023, so it's relatively affordable. Standard application, $65. Looking to register a group of unpublished works, this could be unpublished songs, for example, $85. A group of photographs, $55. And this would be for basically published songs, a group of published songs, I think up to 20 songs. For this one, for the unpublished works, it's up to 10 works. Anyway, for this one, for the up to 20 songs, I believe, $65. So it's relatively affordable, is my point here, okay? Okay, let's wrap up this video. So we did basically discuss at least 3 reasons why it's important to register your copyrights in your creative works. With the most important reason is that it really enhances your ability to enforce the copyright, okay? So again, this has been U.S. copyright attorney Eric Kelly. That's me. And I do work with clients from all over the world and all over the United States. I am a copyright attorney, but additionally I'm also a trademark attorney and a patent attorney. And as we've learned in this video, copyrights are there to protect creative works, and trademarks are there to protect the brand or your branding, and patents are there to protect novel and non-obvious, basically new products, new inventions. And then lastly, you can see here some contact information if you want to reach out to me about intellectual property matters such as copyrights, trademarks, and or patents. Thank you. Please like this video and subscribe to my channel to help me reach others about intellectual property matters. And here are some of my suggested videos on U.S. copyright issues. Thank you.